Divorce and permanent residence in South Africa. The question: a client asked, if I'm a U.S. citizen married to a South African, and I got permanent residence and a green ID based on the marriage, what happens if we divorce? The law. Permanent residence based on marriage. Permanent residence through marriage is granted under Section 26B of the Immigration Act, 2002. It says, if you've been the spouse of a South African citizen or permanent resident for 5 years, you can apply for permanent residence, and the Department of Home Affairs must be satisfied the relationship is genuine, not a sham marriage. But here's the catch. If your permanent residence was granted on the basis of the marriage, and the marriage breaks down within the first 2 years of getting permanent residence, your permit can lapse, unless the spouse dies. This is reinforced by Regulation 23(6), which says that within the first 2 years, you may be called for an interview at Home Affairs to confirm that your relationship is still ongoing. In reality, though, these interviews almost never happen. What if the marriage ends? And if the marriage ends within 2 years of permanent residence being granted? Either spouse, usually the South African, can notify Home Affairs, usually by filing an affidavit at a regional office. Home Affairs Inspectorate will then call the foreign spouse in for an interview. The case is referred to the Director General, who decides whether to withdraw the permanent residence. It's not always automatic. In some cases, e.g. if there are minor children who need the foreign parent to remain in SA, the Director General has allowed the foreigner to keep permanent residence. If the marriage ends more than 2 years after the permanent residence was issued, the permanent residence and green ID generally remain valid. Section 26B says there's no impact on the permanent residence after the 2-year period has passed. Withdrawal of permanent residence, Section 28. Home Affairs has the power to withdraw permanent residence if the holder fails to comply with the conditions under which it was granted. In a marriage-based case, this usually means if the spousal relationship ends too soon, within the 2-year window. Key takeaways. 1. First 2 years are critical. If the marriage ends within 2 years of getting permanent residence, Home Affairs can cancel your PR. 2. After 2 years. If the marriage ends later, your permanent residence usually stays valid. 3. Discretion applies. Even if it ends within 2 years, the Director General can decide not to withdraw PR, especially where children are involved. 4. Green ID remains valid. Once you pass the 2-year mark, your permanent residence is generally safe, even if you divorce later. Let samigration handle your application with 25+ years of expertise to ensure your e-visa is processed smoothly and on time. WhatsApp +27 82 373 8415. info@samigration.com